Alright, we're gonna do some studying again because I was getting bored doing essays and I need to do something to give me energy. And for some reason, streaming my studying gives me energy. We got Finding Paradise music in the background. So what we're gonna do is we're probably gonna do 25 questions speed run. That should take us to about 40-ish minutes? Maybe even 30 to 40 minutes, but we're going to try to be quick because we want to speed run. 25 questions. Let's go. What is the cyclist testimony resulting from the... Why is the cyclist testimony relating what the defendant's employee said at the hospital admissible to prove negligence? A cyclist sued a defendant corporation for injuries sustained when she was hit by a truck owned by the defendant and driven by its employee who was making deliveries for the defendant. The day after the accident, the employee visited the cyclist in the hospital and said, "I'm sorry for what I did." At trial, the employee has testified that he exercised due care. Is the cyclist testimony relating what the defendant's employee said at the hospital admissible to prove negligence? I think, okay, so normally that wouldn't be, but it's because it's an employee of the corporation. I think it's a statement by the party opponent's agent. Because, it's saying, why is it going to come in, right? Normally it wouldn't. It's not that. It's not that. It's, I don't know what, I'm going to go see. Yeah, okay, cool. Allows the employee statement to be substantively admissible as non-hearsay admission by an agent of a party opponent because it was regarding a matter within the scope of employment. Cool. Is the court likely to grant caterer's motion for judgment as a matter of law? A caterer filed a diversity action against the doctor in federal court in state A. The caterer alleged that the doctor failed to pay $85,000 due on a valid service contract from a recent party that the doctor hosted. The doctor did not dispute the existence of the contract between the parties. Okay, so he's not saying that there wasn't a contract. At a jury trial, the doctor testified that he paid $85,000 debt. The caterer testified that the doctor never paid the debt. So he's saying I did, and then the caterer is saying no, he didn't. And produced a receipt showing that the $85,000 payment to the caterer was for a boat caterer sold to the doctor. At close of trial, caterer filed a motion for judgment as a matter of law. Is the court likely? Yes, because the judge should credit the caterer's testimony over the doctor's. That's a summary judgment. Oh, they're all yes. Okay, yeah. So I was thinking, because usually there's 2 yes and 2 no's, but they're all yes. Yes, because a reasonable majority would not have legally sufficient. Yeah, so it's basically asking what the standard for JMOL is. A judgment of a matter of law is a motion made by a party during a trial claiming that the opposing party has insufficient evidence to reasonably support its case. For those of you in the know, it's a lot like a motion for summary judgment, except a summary judgment is pre-trial and the motion for judgment as a matter of law is during trial. It's essentially the same thing, but slightly different standards. The issue of genuine issue of material fact is going to... that's the standard for a motion for summary judgment. But the standard for motion for judgment as a matter of law is whether the jury would not have a legally sufficient basis to find for the non-moving party. Is the testimony of the witness concerning the victim's statement admissible? A defendant was charged with aggravated assault at trial. Is the testimony of the witness concerning the victim's statement? Okay. A defendant was charged with aggravated assault at trial. The victim testified that the defendant beat her savagely, but she was not asked about anything said during the incident. Okay, so she's not on cross. The prosecutor then called a witness to testify that when the beating stopped, the victim screamed, "I'm dying, don't let the defendant get away with it." Okay. Here's the thing. Even if this was a dying declaration, you can only bring it in federal criminal law in a homicide case. So someone had to have died. This is an aggravated assault, so it can't come in under the dying declaration. So it's definitely not that. Is it admissible? Yes, it's a statement under belief, even though the victim did not. No, it's not that. If this was a civil case, you can bring it even if they didn't die. That's being offered for the truth of the matter, sir. I don't know if it's excited utterance. Yeah, I was going to say it's not hearsay. Oh, it is an excited utterance. Oh, okay. As an excited utterance because the victim made the statement immediately after the beating. Oh, okay, yeah, the doy. Yeah, I should have seen that. My bad. So I really got to stick with the rule. If you see an exclamation point, it's an excited utterance. Okay, I would have got that. The woman has sued the investor for specific performance who is likely to prevail. A woman acquired land by a deed that contained the following language in the grantee section to the woman, her heirs, and assigns, provided, however, that said grantee may not transfer any interest in land from 10 years from the date of this instrument. Okay. So two women and her heirs. But if she sells it in 10 years, then not to her. 2 years later, the woman contracted to sell the land to an investor for a price based on a recent appraisal. When the investor's title search revealed the above language in the grantee section of the deed to the woman, the investor refused to close the transaction. The contract was signed as to the woman's title obligation. The woman has sued, so she's basically suing to enforce the contract, right? Who is gonna win? Who is it gonna be? Investor because the woman's heirs don't make the contract. That's not enough. I think she can sell it, right? It's just if she does, it's the interest is gonna go to someone else. So I think it's gonna be D. But process of elimination, yeah. D is correct. Absolute restraints on alienation are void. Okay, so I'm gonna write that down. Okay, I'm gonna write that down. Write that down. Word. Oh, what do we have here? I must have copied this the last time. How do you do this again? File, new, doc, and let's just close this back. Wait, boop. Don't save. This is property. We're gonna do that. Restrictions. Oh. Absolute restrictions against alienation are void. That is what that said, right? Let's make it super duper tiny. Yoink. Absolute restraints on alienation are void. Yeah, it's pretty easy. Okay. Process of elimination. Will a court uphold the new rule? A condominium building located in the bustling downtown area of a major city has a large rooftop pool and a deck, which provides a picturesque view of the city's skyline at night. Many of the residents and owners in the building are young professionals who work in the surrounding downtown area. The residents often gather in large groups on the deck at night. Recently, some residents have begun to complain that these gatherings have become disruptive and unruly, leading to the Condominium Association's board to take action. The board passed a new rule by vote of its members to impose strict curfew for the rooftop deck weekday and weekend nights. Several residents in the building band together to challenge the new view. Will the court uphold the new rule? I think so. Why? Yes, because the rule is valid unless illegal, unconstitutional, or against public policy. Yes, because the rule is valid if reasonably related to furthering a... That sounds like... Who made it? The board. This sounds like government action. Okay. Really? Okay, so it's that weird one. In determining the validity of the rule, the primary test is whether the rule is reasonably related for serving... Okay, cool. I guess I just gotta know that. Because I was thinking that sounded like some government... they call it like rational basis review. What would you call this? I guess like homeowners association board rule making standard. Or equivalent. The primary is whether the rule is reasonable or reasonably related, yeah. Furthering a legitimate purpose of the association. A is incorrect. This is standard for restrictions imposed by the declaration. Restrictions in the declaration are valid unless illegal. Huh. Well, I guess I'll write that down. For HOA or equivalent. Declaration. declaration are valid unless unconstitutional, illegal, or against public policy. Public. Okay. It's all a learning process. How should the court rule? For many years, the city owned and operated a reservoir that supplied the city's residents with water, based on a finding that private entities are more efficient operators of such facilities than public entities. The city sold the reservoir to a privately owned company. Okay. So for years, the city did it, right? And then they gave it to a private owned company. That sounds like a traditional state. Thank you. The city council granted the company a non-exclusive franchise to supply water to residents of the city. After it had operated the water system for a year, the company determined that a city resident had fallen 3 months behind the payment of his water bill. The company terminated the resident's water service on the basis of a company policy that provides for the summary termination of service to customers who fall in more than 2 months behind the payment of their bills. The policy does not provide customers an opportunity for a hearing before the termination of the service, and to have a hearing, you need to have some sort of deprivation of interest. The residents sued the company in an appropriate court, asking for injunctive relief and damages. The resident claimed only that he had been deprived of property without due process in violation of the 14th Amendment. How should the court rule? Dismiss the action because the company is not a state actor for purposes of the 14th Amendment. Dismiss the action because the resident has not proffered payment of any of his arranged in the company and therefore has no right to continue water service. Order the company to give the resident an opportunity for a hearing because supporting an applies to higher entities performing public functions. Traditionally public functions, no. Order the company to give the resident an opportunity hearing because supporting an applies to private franchises granted by public entities. But they gave it a non-exclusive. Yeah, okay, yeah, I didn't. For the action of a private entity to satisfy the state action requirement, the state must be significantly involved in the private entity. The fact that the company supplies a very important good to the public and received a non-exclusive franchise from the city is insufficient to make it a state actor. I'm surprised this one doesn't have an extended, yeah. It just didn't sound like state action. In such an action, the court should find that title is now in. A testator owned Blackacre, a vacant 1-acre tract of land. 5 years ago, he executed a deed conveying Blackacre to the church for the purpose of erecting a church building thereon. 3 years ago, the testator died, leaving his son his sole heir at law. His duly probated will left all my estate, both real and personal, to my friend. Interesting. The church never constructed a building on Blackacre unless... Oh, it doesn't matter, because this part is like only a suggestion, right? And last month, the church, for valid consideration, conveyed Blackacre to a dev. The dev brought an immediate action to quiet title against the son, the friend, and the church, and joined an appropriate state official. Such official asserted that charitable trust was created, which was not terminated. Interesting. Wait, what are you talking about, a charitable trust? Oh, because it would be to the church, right? I see. He executed a deed conveying Blackacre to the church for the purpose of erecting a church building thereon. 3 years ago. Here's the thing. I could see why it would be charitable. Just by looking at it simply, it should be to the dev, right? Because it's the church for building the church. But that's just a suggestion. The land is essentially to the church. All this mumbo jumbo stuff about the testator and his heir and his, probated will, that's like mumbo jumbo, right? Because this is a valid conveyance. So church gives it to dev. That's valid too, so it should be dev. Dev brought an appropriate action to quiet title against the son, the friend. Such official asserted that a charitable trust was created, which was not terminated. I'm gonna say the dev. Okay, yeah, I don't see why it would be. The property never asserts the state because the testator had a valid will. I don't freaking know what that means. The state official receives no title because title belongs to dev. Moreover, the property never... What the heck does that mean? Okay, I don't know I don't know. So, well, I know it's the dev. I don't know what that word is. Will the man be likely to prevail? A man owned land. He took out a loan that was secured by a mortgage on the land. The man had personal liability on the loan. The man sold the land to the purchaser, who expressly assumed the mortgage debt. Is it? Nani? The mortgage debt. The purchaser failed to make 2 installment plan payments, right? And the purchaser expressly assumed the debt. To prevent default and foreclosure, the man paid the overdue installments. After making the payments, the man sued the purchaser for reimbursement. This is easy, right? Because the purchaser is the one who's primarily liable. But if it wasn't him, like, the bank could have gone after the man. So I actually have not come across this. After making the payments, the man sued for reimbursement. Will the man be likely to prevail? No, because the man did not officiate. No, because the man was personally liable on the loan. Yes, because the law of suretyship permits the man to seek reimbursement. Yes, because the man's transfer of land discharged him from any person. That's not correct. I remember seeing the word surety when I was doing this. So I'm just gonna click that. Woohoo! As soon as the man paid an overdue installment, he acquired the right to seek reimbursement under suretyship. Okay, so let's write that down. Okay, assumption of mortgage debt. My A key is like getting stuck for some reason. When A conveys to B and B expressly assumes the debt. What does they say? And B expressly assumes that A can sue B for reimbursement if B does not pay the mortgage under the law of suretyship. So I think that means that, like, A becomes the surety. I'm not sure exactly how to phrase it. If the neighbor sues the woman for breach of contract, will he prevail? Will he? An elderly woman underwent major surgery and spent 2 weeks in the hospital. And what are we doing for breach of contract? If the neighbor sues the woman, underwent major surgery and spent 2 weeks in the hospital. The woman continued to take powerful pain medication for several weeks after she returned home. During her recovery, she offered to sell her car for $450 to her neighbor, who owned a house cleaning service. The neighbor said, "That's great. I need a car to transport all the people who work to me on the job site." Okay, is that an acceptance? In fact, the woman's car was worth $3,000, and the neighbor knew this. He was also aware that the woman had undergone surgery and noted that she seemed out of it because the medication was taken. Several days later, the woman's son found out about the deal and contacted the neighbor, telling him that the woman would sell the car but for $3,450. The next day, when the neighbor tendered $450 and demanded the woman give him the car, she refused. If the neighbor sues the woman for breach of contract, will she likely prevail? I'm thinking no. No, it wouldn't be this, because this is getting into statute of frauds. But statute of frauds only applies to goods when it's, like, worth more than $500, I think. That's $450, so that's gonna be no. It could be incapacity, yeah. Yes, because the neighbor's reliance on the otherwise voidable contract made it enforceable. Yes, because the woman's offer and neighbor acceptance created an enforceable contract. That's great. I need a car to transfer all the people. Let's see. If it's not this one, then this is a major learning opportunity. Oh man, the suspense is really killing. Okay, cool. Physical incapacity of a person necessary to perform under a contract discharges the duty to perform. Here, the woman was incapacitated by the surgery and the pain medication. Wow, 91% of the people got this right. Was I under the average? No, I was above average. No! I mean, I was below average, because I was above the average time. Well, we got it right. Incapacitation. We were able to get it. If it's things like incapacitation, it probably is incapacitation. Incapacity, mental capacity, whatever the term is. Anyway, I think we're making good progress. I think we've only missed like, what, 2 or 3? Out of 9 so far? This is pretty good. What conspiracy offense, if any, can the man probably be convicted of having committed? A man and his friend decided to commit a robbery. Alright, so we already got a robbery. They agreed that the friend would hide in the bushes along a dark street and jump in front of the intended victim, and the man would block the victim from behind. Unbeknownst to the man, his friend had a gun. A short time later, a woman walked down the street and the friend jumped in front of her. Before the man could approach the woman, the friend lifted his shirt and showed the gun to the waistband. The woman ran away. A short time later, a woman walked down the street and the friend jumped in front of her. Before the man could approach the woman, the friend lifted his shirt and shoved the gun in his waistband. The woman ran away. What conspiracy offense, if any, can the man properly be convicted? Of just robbery, right? Because that's the agreement. This is also going to be a learning opportunity. Yeah. The man may be convicted of conspiracy to commit robbery because he and his friend entered into an agreement to commit that offense. The man cannot be convicted of conspiracy to commit armed robbery because he did not agree to commit an armed robbery. The fact shows that he was unaware of the friend's gun. Okay, that is pretty... Bro, how does only 67% get that right? Next question. Should the defendant's motion be granted? This sounds like stuff, bro. This defendant has moved to suppress evidence of his statement, "I killed the clerk," on the ground that this statement was elicited in violation of his Miranda rights. A defendant was validly arrested, for the murder of a store clerk and was taken to a police station where he was given Miranda warnings. When an interrogator asked the defendant, "Do you understand your Miranda rights? And are you willing to give up those rights to talk to us?" the defendant replied, "Yes." Alright, so he was already given Miranda warnings and he gave them up. Are you willing to give up those rights to talk to us? He said yes. When asked, "Did you kill the clerk?" the defendant replied, "No." When asked, where were you on the day the clerk was killed? The defendant replied, "Maybe I should talk to a lawyer." Alright, so he's electing his right of counsel. The interrogator asked, "Are you sure?" And the defendant replied, "I'm not sure." The interrogator then asked, "Why would you want to talk to a lawyer?" And the defendant replied, "Because I killed the clerk. It was an accident, and I think I need a lawyer to defend me." At that point, the interrogation ceased. Later, the defendant was formally charged with murdering the clerk. The defendant has moved to suppress evidence of his statement, "I killed the clerk," on the ground that his statement was elicited in violation of his Miranda rights. Well, he's only violating for the Miranda rights, right? So the lawyer part, well, the statement was violated. Should the defendant's motion be granted? No, because although the defendant effectively asserted his right to counsel, the question, "Why would you want to talk to a lawyer?" did not constitute custodial interrogation. No, because the defendant did not effectively assert the right to counsel, and his conduct prior to making the statement constituted a valid waiver of his Miranda rights. Yes, because although the defendant did not effectively assert his right to counsel, his conduct prior to making the statement did not constitute a valid waiver of Miranda rights. I think it sounds valid. Because the defendant effectively asserted his right to counsel, and the question, "Why would you want to talk to a constant?" Actually, that cool, yeah. The defendant did not effectively assert his right to counsel because such an assertion must be unambiguous. Yeah. Oh, okay. So let's put that. That sounds like something important. Criminal law / procedure. Yeah, I should close the Discord actually in case any pop-up notifications appear. Actually, I'm on streamer mode, so it doesn't matter. Discord. Finding Paradise is a beautiful game, by the way. If anyone's watching, and I know no one is because I see that I have 0 viewers, I highly recommend Finding Paradise. It's such a beautiful game. Where was I? Sorry. Asserting this, was it 6th Amendment right to trial? Or 7th Amendment? I think 6th Amendment right to trial. Or to attorney. Right to counsel. Must be unambiguous to be an effective assertion. Um, the defendant did not effectively assert his right to counsel because such an assertion needs to be unambiguous. The defendant's statement, "Maybe I should talk to a lawyer," is not unambiguous request for counsel. In addition, the defendant unequivocally waived his Miranda rights prior to making the statement. I'm surprised that more people got this one right than the last one, to be honest. Is the buyer entitled to specific performance of the contract? Oh, it's going to highlight everything. God dang it. Is the buyer entitled to specific performance of the contract? A seller owns a 400-acre tract of land with 5,000 feet of frontage on the Court County Highway. The seller and a buyer entered into a written agreement for the sale of a portion of the tract identified only as a parcel of land containing not less than 100 acres and having not less than 1,000 feet of acreage on the county highway, whose exact location and dimensions are to be determined by the parties hereto at a price of $8,000 per acre. Shortly after the execution of the agreement, the parties met to stake out parcel of land to be sold, but they could not agree. The disagreement intensified, and the seller repudiated the contract. Buyer has sued the seller for specific performance. The seller has all available defenses. Is the entitled all available defenses? I mean, if it's what I'm thinking, it's that the land is not sufficiently described. But let's see what it says. Is the buyer entitled to specific performance? I'm thinking no. Is a contract for the sale of real property that requires further agreement on an essential element cannot be specifically enforced? No, because the purchase price was not fixed by nor determinable under the contract terms. It's also true, yeah, because it says not less than. But does it need a purchase price, actually, for the sale of land? No, because the contract for the sale of real property that requires further agreement on an essential element cannot be specifically enforced. Could it not be? I'm going to go with the price. Okay, so yeah. Although this response correctly concludes that the contract cannot be enforced, it misstates the rationale. A sale price may be engrossed, as here where the price depends on the actual acres. Okay, so we need to know that. So the sale price can be... Sale price does not have to be exactly. The statute of frauds requires a writing evidencing an agreement to sell real property to identify. Although courts are sometimes lenient with this requirement, the writing must contain some evidence of specific real property to be sold. The writing in this case noted that the parties were yet to agree on what land to be conveyed. Equity cannot provide... Oh, so it kind of was what I was saying, just in a different way, I guess. No, because a contract for the sale of real property that requires further agreement on an essential element cannot be specifically enforced. Okay. There's no way that 77% of the people got that right. What the heck? And people are crazy. Should the witness's notes be admitted? Oh, this is the 1000th question. I have to get this one right, unless if I don't get it right, my computer explodes. Several defendants, senior executives of a corporation, were charged with securities fraud. The government called as a witness another executive of the corporation who had not been charged and who had been given immunity from prosecution to authenticate handwritten notes that she had made after meetings of the corporation's management at which the alleged fraud was discussed. The witness testified that she had prepared the notes on her own initiative to help her remember what happened after the meetings. After this testimony, the government offered the notes into evidence to establish what happened. Should these witnesses' notes be admitted? I think so, right? Because she had personal knowledge. Past recollections recorded, right? They're not business records because she made them for herself. I think so. I forget the exact... No! We're doomed. The notes do not constitute a past recollection record, but there has not been a sufficient foundation laid to establish that the witness' memory in question is in question or the context. The notes are not qualified as a past recollection because there had been no foundation laid that the witness' memory is in question. Okay. So if I understand that correctly, Man, I really wanted to get the 1000th question right. Evidence. Past recollection. Recorded. This only comes into play if the witness's memory is called into question. If she remembers it, then her notes do not come in as a past recollection recorded, and they need to satisfy some other hearsay exception or X-caption. I really wanted to get the 1000th question right. It makes me a little sad. Which motion should the retailer file to challenge the jury's damages award? A retailer from State A filed a diversity action against a manufacturer from State B in federal court in State A, alleging that a breach of contract is seeking $195,000 in damages. The case went to trial, and after 4 days, the jury returned a verdict in favor of the retailer, but awarded only $2.25 for compensatory damages. Under federal law, a judge who believes compensatory damages are so excessive as to shock the conscience may offer plaintiffs the choice between a new trial or a remitter of the excessive damages. Under State A law, a judge who believes damages are excessive may offer plaintiffs the choice between a new trial or a remitter, and if the court believes the damages are inadequate, it may offer defendants the choice between new trial or additor. Which motion should the retailer file to challenge the jury's motion? I think this is like a clever way to choose choice of law. So A, under diversity against manufacturer from State B in Fed court in State A. Perhaps this is procedural, so then federal will come into play. Federal rules, and under the federal rules. Well, they definitely need to move for a new trial. Maybe it's just this one. Is it not gonna tell me? Is it seriously not gonna tell me? I got it right. The retailer's only option is to file a motion for new trial on the ground that the verdict is inadequate, because additor is not allowed in federal court and has been held unconstitutional. Yes, you can't just add damages. The jurisdiction of federal courts is concurrent with state courts. This means that a particular controversy that is litigable in federal court may also be brought in state court. When determining whether to do an Erie analysis, the threshold question is whether there is a controlling federal rule or federal statute. If any federal law control is on point, there is no Erie problem. However, in the absence of a controlling federal statute, the question becomes whether the issue at hand is substantive or procedural. In the Erie decision, the U.S. Supreme Court held that federal court sitting in diversity must apply the substantive law of a state in which on substantive issues. This includes the state conflict of law rules. For all procedural issues, a federal court sitting in diversity must apply federal procedural rules. Okay. When a potential Erie analysis arises on the MBE, pay close attention to the facts. If the court is not sitting in diversity and is exercising federal question jurisdiction, federal law will apply. There's no need to examine applicable state law. This is a diversity case in federal court, which means that there's no controlling federal law. The court should apply the state substantive law in the state of which it sits in. Well, I don't quite understand it, but I was able to get it through my thought process. The defendant should be... After being fired from his job, the defendant drank almost a quart of vodka and decided to ride the bus home. While on the bus, he saw a briefcase and mistakenly thought it was his own. And he's also drunk. And began struggling with the passenger carrying the briefcase. The defendant knocked the passenger to the floor, took the briefcase, and fled. The defendant was arrested and charged with robbery. Is robbery a specific intent crime? Law students can always take a laugh even for ridiculous bar facts. Defendant was arrested and charged with robbery. The defendant should be acquitted because he used no threats and was intoxicated. His mistake negated the required Although he did not use threat force, he did use actual force. Yeah. That was just asking a specific intent crime. Is the bank teller's testimony admissible? The man was charged with attempting to cash a forged check. At trial. What am I doing? When a man entered a bank and presented a check for payment, voila, the bank teller recognized the signature on the check as a forgery because the check was drawn on the account of a customer whose handwriting she knew. Oh, okay, so she already knew the handwriting before. The bank teller called the police. Before the police arrived, the man picked up the check from the counter and left. The man was charged with attempting to cash a forged check. At trial, the prosecutor has called the bank teller to testify that the signature on the check was forged. Is the bank teller's testimony admissible? Yes, because she was familiar with it before. What's it called? As a late witness, you can testify to the authenticity or whatever of a signature or handwriting, provided that you didn't become familiar with it because of the litigation. Yes. It is admissible. But I don't like why that says it. I mean, if that's the case, that's a rule. I don't know. Yeah, okay. Yeah, I don't like how they worded it. This is essentially just saying yes because it's relevant, which, like, I guess allows lay opinion testimony when it is rationally based on the perception of the witness and is helpful to the jury. Oh, that's what it was saying. My bad. Here the teller knew the signature. You know, I'm gonna write that down because I didn't know that. I didn't know that was the exact rule. Lay opinion. W. FRE allows lay opinion testimony when it is rational. Of the W and is help to the jury. Cool. FRE allows lay opinion testimony when it's rationally related to the perception of the and helpful to the jury. Making real good progress, I think. A woman died. Is the daughter's conservator... If the daughter's conservator wins an ejectment action against the neighbor, why is the reason that she wins? A woman died, devising the land that she owned in another state to her daughter, who was 17 years old. And who wins? The daughter's conservator. A neighbor who owned the property immediately adjacent to the land wrongfully began to possess the land at the time. Alright, so we got a freaking adverse possession. For 24 of the next 25 years, the neighbor planted and harvested crops on the land, hunted on it, and parked cars on it. However, in the 6th year after his first possession of the land, the neighbor neither planted crops nor hunted nor parked cars on the land because he spent the entire year living in Europe. The neighbor built a small gardening shed of the land. So that's like a question as to whether it's continuous, even though I think it is still. The neighbor built a small gardening shed on the land, but he never built a residence on it. When the daughter was 28, she was declared mentally incompetent and had a conservator appointed to oversee her affairs. Since then, she continuously resided in the care facility. The applicable statute of limitation provides an ejectment action shall be brought within 21 years after the cause of action accrues. But if the person entitled to bring the cause of action is underage or mentally incompetent at the time of the cause of action accrues, it may be brought by such a person within 10 years after attaining age 18 or after the person becomes competent. If the daughter's conservator wins, why does she win? So why was this person who was 17... So for 24 years he lived, but 24 minus 6, 18. So if that year he was in Europe is no longer continuous and they only have 18 years. It's definitely not C. It's probably that. Yeah. The time period required to have his first possession in the jurisdiction is a minimum of 21 years. The neighbor has not been continuous possession. He spent 1 year in Europe. Ah, okay. I think I'm only gonna do like 3 more. Will the mother statute of frauds defense likely to be successful? In financial straits and needed $4,000 immediately, nephew asked his uncle for $4,000 loan. The uncle said that he would lend the money to the nephew only if the nephew's mother would guarantee the loan. So suretyship falls into the statute of frauds. Or is it an exception to the statute of frauds? No, I think it falls under the statute of frauds. After the nephew's suggestion, the uncle then telephoned the nephew's mother, told her about the loan, and asked if she would guarantee it. She replied, "Yes, lend my son $4,000, and I will pay it if he doesn't." The uncle then lent $4,000 to the nephew, and the nephew orally agreed to repay the amount in 6 weeks. The next day, the nephew's mother wrote to him and concluded her letter with the words, "Son, I was happy to do you a favor by promising your uncle I would pay you if you don't." Neither the nephew nor his mother repaid the loan when it came due. And uncle sued the mother for breach of contract in that action. The mother raised the statute of frauds as her defense. Will the mother's statute of frauds be successful? If it isn't, it's because if it isn't, then it's because like the writing doesn't count or because performance has been done or whatever. That doesn't matter. That doesn't sound like in writing. Although this is a good learning opportunity. Oh, okay, cool. Wow, so it does satisfy. The mother's letter to the son satisfies statute of frauds requirement for suretyship, contract and to be writing. This letter identifies both parties, describes the subject matter and terms, and is signed by the mother. The fact that it was not made contemporaneously with a promise to pay the nephew's debt is of no consequence. Oh, okay, interesting. That's a good learning opportunity. I suppose this would fall under contracts. Contracts. Paragraph. Statute of frauds. Writing a requirement. Which requires writing that identifies both parties. Describe subject matter and terms, and is signed by the party to be bound, or I guess the surety. I'm not sure if bound is the word. So, like, even a letter written to the third party that's signed by surety but never sent to the lender is a valid writing under the statute of frauds. Alright, good learning opportunity. Next question. Can the man properly be convicted of felony murder? A man entered a store with a gun, planning to rob the store. He was unfamiliar with guns and thought that the safety lock was on. So he's committing a robbery, right? When the store manager refused to give him money, the man shook the gun at her to scare her into cooperating. The gun fired, killing the manager. A clerk ran in from behind the stock room. The man fired a shot into the air to scare the clerk. Unbeknownst to the man, the clerk had a heart condition, and the fright caused her a stifle for. I think so for both, yeah. Yeah, because basically, like, any murder in a felony is like a murder. Any killing during a felony is a murder. The death must have been caused during the commission of the attempted felony. So if the felony's done, then it doesn't apply. The death must have been a foreseeable result of the commission of the felony. In this case, the defendant had the intent to commit robbery. The murder is foreseeable consequence when committing a robbery with a dangerous weapon. Therefore, the man can be convicted of both deaths. Okay, second to last. Common law rule against perpetuities is unchanged. An appropriate action to determine ownership of Greenacre. The court should find the title is vested in 60 years ago by a properly executed and recorded deed. A father conveyed Greenacre, a tract of land, to son for life, then to son's widow for life, then to my son's child or children in equal shares. The son at that time was 6 years old. Shortly thereafter, the father died testate. His son was his only heir at law. The father's will left his entire estate to the local church. "25 years ago, when he was 41, the son married his first wife, who was then 20 years old. They had one child. The first wife and child were killed in an automobile accident 3 years ago when the child was 21. The child died testate, leaving his entire estate to the charity. His father was the child's sole heir at law. 2 years ago, the son remarried. This year, the son died testate, survived only by his widow, to whom he left his entire estate. Then to my widow for her life, to whom he left his entire estate." The common law against rules against perpetuities. Isn't it just to the widow? The widow, because her life estate and her inheritance from the son, who is the father's sole heir at law. The widow, under the terms of the father's deed, with the remainder to the charity, as successor in interest. So I have to find out what happens afterwards. No, I think it's D. Yeah. It's important to remember that vested interests are not subject to RAP. Oh, yeah, okay, I think I had that, because I never even was considering RAP. Despite the fact that the son was only 6 years old. All interests would clearly vest or fall within the son's life. The widow's interest of the life estate vested upon her marriage. Likewise, the son-child vested upon his birth. Alright, this will be the last one for today. And it's a short one, thank God. The defendant's motion for a new trial would be most likely granted if the juror is willing to testify that he voted for the plaintiff because he... So the defendant's motion for a new trial. So why are we going to get a new trial? A plaintiff sued a defendant for fraud. After the verdict for the plaintiff, the defendant talked with the juror about the trial. The defendant's motion for a new trial would most likely be granted if the juror is willing to testify that he voted for the plaintiff because he misunderstood the instructions concerning the standard of proof, was feeling ill, and needed to get home quickly. Relied on testimony, the judge shook in and ordered the jury to disregard. I think it's this one because this is the only one that deals with stuff that comes from the outside. Yeah. Although jurors may not testify about anything that occurred during the jury deliberations, the effect of anything the jury's mental processes concerning the verdict and indictment, when the jury testimonies regarding extraneous judicial information proffer outside influences, such testimony is admissible and will likely be grounds for a new trial. Okay, I'm gonna write that down. Like what made jurors not have a Civ Pro one. I don't. Civ Pro. What? Bro. They can't testify about anything. What do you mean the effect of anything on that juror? So, like that happened in trial? Any juror's mental processes concerning the verdict or indictment. But a juror can testify about improper, extraneous, prejudicial information or outside influences. Alright, let's stop for now so we can go back and do some essays. 76%, that's not bad out of 20. Alright, stream over. Bye.